Hearing in the appeal, London Borough, Lambeth, and Secretary of State for Housing, Communities and Local Government and others.
Yes, Mr. Reid.
Please, my ladies and my lords, I appear on behalf of the appellant in this matter, alongside Mr. Matthew Henderson, Mr. Daniel Kalinsky, and Ms. Sasha Blackmore appear on behalf of the Secretary of State, and Mr. Lockhart Mummery and Mr. Vanderman appear on behalf of the third respondent in this matter. My lords, this is an appeal relating to the legal effect of a decision of the local authority to grant permission on the 7th of November 2014, as my lords and ladies have seen.
Yes.
I was going to deal briefly with some of the facts relating to the matter, but I expect that the court has already had the opportunity to see those facts.
And we've taken the opportunity.
I'm grateful. In which case, perhaps I can deal very briefly with the factual matters before I turn to my submissions. I'll deal briefly with my submissions and then go on to each of the heads of those submissions in more detail. Can I deal then firstly, please, with the factual position? And if I ask the court, please, to turn firstly to page 67. Page 67 of the bundle. It's the core in the core volume for those using the paper version. The court will see there the 1985 planning permission that related to the site when it was first developed. It was a consent giving permission to erect a DIY unit and an industrial building, but was subject to condition 6, and the court has no doubt seen that condition 6 was restricting the use of the retail unit to certain purposes. Essentially DIY and home and garden improvements and builders merchants uses, but there was a clear restriction on the face of the 1985 permission. One can then note, at least for my purposes, the next part of the chronology, which is contained again in the core volume at page 433, a decision that was reached by the authority on the 30th of June 2010, and which was an application under section 73 that no doubt the court has seen to vary the condition that your lordships have already seen and ladyships have seen in respect of the 1985 permission. So an application specifically to vary. The terms of that document identify what the permission was that was to be granted, and that was for a variation of condition 6. And in terms that the court will no doubt see are similar in form to the subject permission which is before this court. But what one can also see is page 434, that there are a series of reasons for granting a planning permission, but nevertheless a summary of those reasons, not the full reasons, and it indicates, as your lordships have no doubt seen on the third line, the planning permission, it was decided, should be granted subject to the conditions listed below. And those conditions include condition 1, which is a repetition of that which was described in the application terms in the first part of that notice. Your lordships will also see that the reason given for the condition to restrict the nature of the use was in order to ensure that the level of traffic generation is such as to minimise danger, obstruction and inconvenience. And so there was an extension of the extent of the use that could be had of the retail unit, but for very specific purposes. The next document I'd ask the court to look at is at page 398 of the bundle. forgive me, 437, page 437 of the same core volume, please. The document at 437 relates to another application for a change of the nature of the goods that can be traded from the premises, but amounted to a refusal on the part of the authority. The extension was, again, to widen the amount of goods that could be traded rather from the premises. But the reasons for refusal, at essence, which are set out at page 438, at essence, made clear that the reason for the extension, or the reason for the refusal in respect of the extension, was because of the effect on trip generation. Now, that application was an application essentially for food retailing, and so there was an intent on the part of the applicant to apply for food retailing, and it was refused on that basis. And just in order that your Lordships can see that, because it wasn't on the face of the document itself, if your Lordships turn to 398 in the core volume, at the bottom of the page, it says application to widen the range of goods to include food as the heading. So your Lordships hope you can see. In August 2013, an application was made to allow the full range of retail goods to be sold from the store. It was through the removal of Condition 1, this application was refused for traffic/transport reasons. And that statement is within the applicant's, consultants or representatives' explanatory document for the certificate of lawfulness that your Lordships have seen. So that was part of the history up until a further application was made, essentially repeating the process, in which is the subject matter of the consent that is before this court. And that's to be found, of course, at page 441, as the court has seen. Your Lordships will see, again, that there is a description of the nature of the application, which was the subject matter of the determination, again under section 73, for the variation of Condition 1, but it went further and identified the original wording that was the subject matter of the revised condition contained in the 2010 permission, and then also the proposed wording, as your Lordships can see, and my lady can see at page 442, at the top of the page, proposed wording of condition, and proposed wording, forgive me, and of that it is described in terms what is to be the nature of the restriction, and the restriction is in terms for non-food goods only. So there was an application to vary for all purposes. The proposed wording was to restrict for non-food goods only. Your Lordships and my lady will see the proposed wording, but it doesn't, of course, say of a condition, but I shall make the submission at the appropriate time that one immediately asks the question, the proposed wording of what? And the answer must be, I will submit, of the proposed condition.
But the proposed wording, where does that come from? I mean, the application, where do we have the application for this permission?
No, not before this court.
But whose proposal was it?
The proposed wording was described by the applicant themselves.
Yes. And so that's what they applied for.
Correct.
And was it open to the authority to grant permission for more than they applied for?
It would potentially be open to them if it was not a substantial change in accordance with the Bernard Wheatcroft decision.
Yeah, but in this context, it was a fundamental change because that's what it had been all about.
Quite so.
Food and non-food.
Quite so, my lord. The position, at least on the law, is that it should be a substantial change. There is something of a statutory framework to it, which is that when one is granting permission for an application. And so the terms of that application will necessarily fundamentally prescribe the nature of the determination by the...
But I mean, if a week after this permission had been issued, a third party, a local neighbour, had said, hey, hang on, you've granted permission without a condition which was clearly intended, could they not have applied to quash the decision?
The third party?
Yeah.
Yes.
And could the authority have done so itself?
Yes.
But it could have applied to quash its own permission?
Yes, if one is looking at the legal position.
Yeah.
Yes.
I see. But you're not arguing now that the permission itself is invalid. You're not sort of...
No, I accept that it is effective for the, and we have always accepted that it is effective for the purpose that it was granted. Forgive me. It was effective to do what it said. One has an implementable consent.
So basically it comes down to the implied condition point.
Well, my lord, I do hold on to the interpretation argument and also Chartbrook in the corrective
But you've got to put something in to enable, I mean, you say that wording is sufficient to amount in effect to a condition.
I do.
Which can be enforced.
Yes.
I'm not saying it's a limitation.
I'm not saying, I'm sorry.
I'm not saying it's a limitation because you're not questioning the I'm your man case.
Quite so.
So we're back to a very short point as to whether there's an implied condition or an effective condition in some way.
Yes, my lord.
That turns on Chartbrook and so on.
Well, yes, my lord, I certainly agree that the essence of my case, and as my lord has seen in the court below, the essence of my case focused upon implication. However, there is an interpretative route to a similar finding, insofar as if one was looking at the permission as a whole, the permission includes, properly read, that wording as a condition.
Yeah, but I'm not sure what the difference is. I mean, you're interpreting this document and you're saying one way or another there's something which can be enforced as a condition.
Yes, the only distinction, I think, is that under an interpretive approach, I'm saying that properly read, the document already includes the condition, whereas under the implication route, the court would find that there are grounds for reaching a conclusion that the condition should be implied into the document.
Yeah, well, I'm not sure. I mean, we had this great argument in Arnold and Britton, and my judgment tends to elide those two sort of propositions, but I agree I was in the minority, but I'm not sure I was in a minority on the principle. Anyway, we'll look at that, but you rely on applying sort of the Chartbrook sort of approach in a planning context.
I do, yes. Yes, I do. And I'll, of course, come on to explain the nature of the way in which I put my case shortly. My Lords, I can deal with the factual position in a little more briefly when I come to deal with that after this decision. But can I ask, my Lords, just to note two other points with regard to the decision notice itself, and the court has no doubt seen it. That in the summary of the reasons for granting planning permission, it stated that the planning permission should be granted subject to the conditions listed below. And those conditions include, and it's important for, at least for the purposes of dealing with the Court of Appeal's position, condition 3, which sets out an approach that should be taken towards mitigation measures, if such are necessary, after further traffic surveys. So after the grant of that consent, shortly after the grant of that consent, in fact, there was an application on the part of the second respondent for a certificate of lawfulness of proposed use and development. and that was refused by the planning authority. The second respondent then appealed that to the first respondent. The first respondent accepted that by way of a decision letter that is within the court's bundle at 449. Forgive me, that actually I think is a wrong reference. It's in, yes, indeed, it is 449. I was right, in 449. And this council then appealed under section 288, the Town and Country Planning Act 1990, and the court has seen that Mrs. Justice Lang dismissed the council's appeal, and the Court of Appeal dismissed the council's further appeal. My Lords, can I deal then very briefly with what the overarching submission is that I make in terms of the two heads of challenge? And I deal firstly with interpretation and then implication. I deal with it in that way in deference to the Court of Appeal, even though my case was set out differently previously. The Court of Appeal said that it was appropriate to deal with interpretation before implication. So looking at interpretation, the approach, we say, is a standard one. One should look at what the document in question means, and in doing so, one should look at the words, the purpose, the words of the relevant document, the purpose of the document, and common sense. One can take into account, in a planning context, documentation that has been incorporated by reference, or in circumstances where there is an ambiguity in the document itself. I should say that incorporation by reference, or indeed ambiguity in taking into account extrinsic evidence, we say, isn't actually critical to our case. Our case is made out, we say, on the basis of a plain reading of the document itself. But the meaning of the planning permission is capable of two readings, we say. The first is that the proposed wording that the court has seen, and I describe it like that, the proposed wording amounts to a condition when properly understood, or the Secretary of State is right and the proposed wording is simply a limitation. But in circumstances where there are two possible interpretations of the document, the authorities say that one can give weight to what most accords with business common sense, and we say that our interpretation accords more with business, certainly accords with business common sense, and the reverse is true if one adopts the Secretary of State's position. As my Lord Carnwath noted, we say I'm your man actually doesn't affect the proper interpretation of the document here, because it wasn't prescriptive as to what was a condition and what amounted to a condition on a permission. That is a matter of reading the document as a whole. Alternatively, under the interpretation head, our position is that one should adopt the corrective interpretation in Chartbrook. We say it's clear that a mistake has occurred, and it's a mistake in the language of the document. Essentially, it is a matter of the local authority putting the condition in the wrong place on the document. And so that is, we say, patently a mistake of language, and one that leads to irrationality by way of consequence. With regard to implication, my Lords and Lady have seen our position on that. The approach, and of course I make the statement with some hesitancy because the court is no doubt aware of it, but the approach that we say needs to be taken when one is reaching a conclusion as to how to imply is to get as close to the presumed intent or the purpose of the document itself. And that is the obvious intent reached by way of the objective evidence available under the restrictive terms of the Ashford case. And if one is looking at it on that basis, it is clear, we say, what the intent was. It doesn't take very much in the way of detailed submissions to make that point. And indeed, the applicant at the time of making the application knew that it was, knew the terms of the application that they were making, and essentially that a windfall was obtained by virtue of the authorities' wording of the document in question. One can also clearly identify what the condition is that needs to be implied here. All one needs to do is look at the four corners of the document in order to understand the purpose of the document and indeed the nature of the condition that should be imposed in this case. That in simple terms is the approach that we take towards both major limbs in our case. Can I then deal with the interpretation case firstly? My lords and lady have seen the approach that the parties have taken towards dealing with this appeal and have addressed a number of issues in order to inform the court as to the approach that should be taken. What I propose to do, however, in my submissions is firstly address the approach that should be taken towards interpretation of the planning permission and the material that should be taken into account. I'll then deal with how that applies to the particular planning permission that we are addressing in this case. I'll then go on to deal with the Chartbrook principles and whether they apply without modification and their application here. So can I deal then with the approach to be taken towards interpretation? We say that on the basis of Trump, the position is clear. It is that there is no special approach that needs to be taken towards the interpretation of a contract. And if my lords take up...
We've seen all this. I mean, I don't
Very
know.
good.
But I mean,
Yes, this is pretty familiar.
I felt so. No, simply as a matter of courtesy, I was going through the various steps in my argument, but I can shortcut that.
It's fairly familiar.
Indeed
But
so.
I mean, the only thing that Trump adds is to say, well, don't treat planning permissions as in a special category. You've still got to apply ordinary principles, but against a background, this is a public document. But I mean, here you're relying entirely on things on the face of the document. So we don't get the sort of problem where I might get in other cases about the factual matrix.
No.
So we're really back to ordinary principles of interpretation as set out in Arnold and Britton, Marks and Spencer, I suppose.
Quite so. My lord, in that case, I don't propose to, as your lordships have indicated, don't propose to go into any of the detail that I was going to deal with regard to the interpretative principles. But there is the principle that I referred to earlier on in my submission, namely that if one has two potential readings of a document, one can weigh into the balance which interpretation most accords with business common sense. I can give my lord and lady the reference for that. That may be sufficient for present purposes, rather than taking...
Well, you set them out at great length in your submissions, I think.
I did. Yes, indeed so. Well, simply for reference, it's the decision in Wood and Capita Insurance, and the relevant page in the bundle is 1058, and it's paragraph 11, which makes that point. But, of course, when one's looking at what those principles relate to that are contained within both the Trump decision, Marks and Spencer and others, one is seeking to get to the purpose of the document, bearing in mind, as my Lord Carmouth has indicated, the need to consider a restricted amount of documentation in light of the document being a public one. So for those, for the reasons set out in our written case and applying those principles here, there's a straightforward approach that needs to be taken when interpreting the document itself. And so can I then turn to the factors that I say indicate that on an interpretive basis, not the Chartbrook basis.
Can I just pick up one point? I mean, I was surprised that no one seems to refer to the case of Aberdeen City Council and Stuart Mill. I mean, if you go to Arnold and Britton, which is the first of your authorities, where Lord Newburger sort of summarises the principles, yes, on page 477 of the 476 to 77. And his sixth principle on page 477 is related to the Aberdeen City Council case. and that's picked up again by Lord Hodge in his judgment at page 487, and by myself at page 499, and it's a particularly striking example of the court really rewriting the relevant clause of a contract to give effect to what the intention of the parties was. But we can come back to it.
Yes, it wasn't something that I was that I'd concentrated on in my submission, certainly, but it does show the extent as scanned it, certainly at paragraph 113.
Yeah. But I, in my judgment at 498, I put it in the context of the Chartbrook principle.
Yes.
And I refer to Lord Clark's judgment in that case on page 499, really saying that these principles all go together, and you're just trying to find out what the meaning of the document is, and if you have to write in some words to achieve that, you do.
Yes, I certainly noted my Lord's observations in Arnold and Britton, and the judgment, of course, of Lord Neuberger in that case adopted a two-part approach towards that issue, which is how we've presented it. But
yes, but I think the thing about the Aberdeen case is actually at the end of the day the two sort of come together, two approaches, and produce a sensible result, which is why I thought it might be useful.
Thank you. Thank you. Can I then potentially return to that if I have the opportunity later on in my submissions? But before doing so, if I go on and address the 9 factors that I propose to set out before the court, indicating how the document should be interpreted.
Yes, I mean, I was really flagging it up so maybe the other side can address it rather than you need to. Yeah.
So, maybe that I deal with it by way of reply.
Yeah.
My Lord, I set out the factors. I, of course, note that one should look at the wording of the document, perhaps firstly, but in this instance, it's important, we say, to at least take into account some of the factors in understanding what the proper interpretation of the document is. I've said earlier on that extrinsic material can be used in this case in accordance with Shepway. It can be in this case for 2 reasons.
You don't need it here, do you?
Quite.
I mean, why do you make it more complicated? Maybe,
well, quite.
Sorry, I don't want to keep on.
Well, my Lord, it's obviously something that lawyers can often fall into, is trying to make as many points as possible in order to make a case rather than the fewer, which can be sometimes...
I mean, to take it simple, if you look at this document, 441, the London Borough of Lambeth hereby approves the following application for variation of a condition as set out below. So it's an application for variation of a condition, original wording set out there, proposed wording set out there. Now, if you stop there, presumably it would be pretty clear that what was being done was to substitute, in effect, a different condition.
Yes.
And it's only when you sort of go on and you sort of see these and setting out particular conditions that you begin to have doubts. But, I mean, isn't that the sort of point that actually what they're seeking to do is perfectly straightforward?
Perfectly straightforward, we say. Absolutely, my Lord. But it's perfectly straightforward insofar as the condition is not only set out in terms, but one just simply can't understand that wording, proposed wording, without giving it some sort of meaning in accordance with the application that was made. And it must therefore be a condition.
It's what they've approved instead of the original wording.
Well, indeed, if for example, this condition section had been omitted from this permission, there would be no doubt at all, and the Secretary of State would say there is no doubt, that this was a conditioned permission. And I do repeat and set out, at least in Trump, that one should be looking at the document as a whole on that basis. My Lord, in that case, I have set out in a detailed form in my written submissions some of the factors, and it may be that then I cut down those factors. I shan't repeat them. They are set out in the document. Can I ask, though, the court to note a few other matters, the first of which is that, and I repeated that the application itself was to propose an amendment to the condition. So what the applicant was intending on receiving was a condition document. And I've referred to it earlier on, the reasonable reader looking at the document would know that a document like this cannot grant permission for something that is substantively greater or fundamental alteration of that which has been applied for. And in this case, there would plainly be a fundamental alteration if the very thing that had been applied for is not what was granted, despite a permission being granted.
Does it in fact grant permission for food use? Or is that simply a consequence of the way in which it was done?
It's a consequence of the way in which it was done. It's a consequence of that. The next factor or reason that I ask the court to take into account relates to what is suggested by the Secretary of State as part of what the reasonable reader would understand, which is that this is a standardised document. There's no evidence that this is a standardised document. There is no prescribed form for a planning permission. Somewhat oddly, it might be thought, but nevertheless, that is what has been decided by Parliament, that there shouldn't be any prescribed form for it. And so, in the absence of that evidence, it simply is not appropriate for the court to reach the conclusion urged upon it by the Secretary of State that this is simply following the standard wording and needs to be adopted and needs to be read in a standardised way. Indeed, even if that were right, this, of course, is not a standardly worded document. By putting in the sort of wording that is in the first part of the description of the development that's permitted, it moves outside of anything that can be regarded as compliant with or comparable to a standard document. I've dealt with I'm Your Man, and we have
presumably accept that the document has, that the reasonable reader is taken to be
Yes, absolutely. I don't.
Importance of specifying conditions as conditions and putting in the reasons.
Yes, I accept that. What the reasonable reader would know is that I'm Your Man says that if there is to be a restriction on, in this case, retail use, it should be by way of a condition. But that doesn't answer the question. The question is whether or not there was a condition here, at least for our part. So it doesn't go far enough, we say, to simply refer to that principle and say, well, that's determinative of this case. What the reasonable reader would also know, as I've said earlier on in my submissions, is that I'm Your Man does not say actually what amounts to a condition within a permission. And I'm Your Man was not it wasn't a case where the local planning authority had granted permission. It was a case where the Secretary of State had. And so it's not authority for saying that the condition has to be in the list of conditions set out in the document in question. Again, one reads the document as a whole and asks whether or not what are the conditions that are attached to it. We've also said in our written submissions that the I'm Your Man authority, even if it did have some substantive bearing, would be counterbalanced by the Bernard Wheatcroft decision, insofar as the reasonable reader would have to grapple with, on the one hand, I'm Your Man, and on the other, knowing that the permission couldn't grant something that amounts to a substantial alteration of the application.
It wasn't argued in I'm Your Man that it was an implied condition, was it?
No, it was argued that there was an implied power.
Yes, but I mean it's slightly odd because there was this 958 dictum in the Francis and Useley case,
Yes.
which basically treated that as an implied condition.
It,
And it seems rather odd that that wasn't argued.
no, well, quite. And it was not only in in the Francis case simply referred to was explicitly on, at least in Lord Justice Parker's decision, actually explicitly treated as an implication.
Are you going to take us to that?
I will, yes. I've referred, turning to the next factor that I proposed to put before the court, to the linguistic difference that can be taken from the linguistic difference in the interpretation of the document, and that there are two potential readings here. Either one reads it in the way that the Secretary of State would have it, namely that the proposed wording is simply a limitation and not a condition, or that it actually is a condition on the face of the permission. And for the reasons that I've already said, what accords most with business common sense must be that which reflects the application itself, namely the planning authority's approach. The next matter concerns the observation, indeed one of the factors taken into account by the Court of Appeal in reaching its conclusion about interpretation, to the effect that Condition 3 acted as a safety net for food retailing. We say that that was wrong and should not be followed by this court. Not only is it not in accordance with the purpose of the document as is described, but in any event, as a matter of fact, the terms of Condition 3 set a baseline by way of a transport assessment, and the transport assessment itself was only related to non-food retailing. In any event, and more importantly perhaps, there is an inconsistency, we say, between the Court of Appeal taking into account Condition 3 as a safety net, and on the other hand, reaching the finding that it did explicitly in respect of what the reasonable reader would understand the document to mean, which is set out at paragraph 27 of the judgment. And if my lords and lady look, please, at the judgment of the Court of Appeal, paragraph 27, which is at page 186 in the core volume. Having looked at the document itself and the interpretation principles that need to be adopted, paragraph 27 says this: the question is whether the reasonable reader would understand the words of the decision to mean that the planning commission granted him permission for unrestricted AE1 use. In my judgment, he plainly would not. It limited the goods that it permitted to be sold to non-food goods. So the Court of Appeal, from that perspective, reached a conclusion that the reasonable reader wouldn't consider that there was an unrestricted A1 use. And yet, on the other hand, when reaching the conclusion as to how to take into account Condition 3, at paragraph 52 of the judgment on page 193, then...
Isn't the only point being made that restrictions on Class A within a use class have to be imposed by way of condition rather than in terms of the grant of planning permission itself?
Yes, my Lord, but there is an inconsistency, I say, in terms of what at least the court was there saying, which was that the reasonable reader would understand that there had been a restriction imposed. At least that was the purpose or intent of the document.
Just put it into the mind of the local authority instead of the reasonable reader for the moment. They meant only to permit limited goods within Class A, and then to read Condition 3 as being in some way designed to deal with food retail would not be consistent with that.
Correct.
Is that the point?
Yes, that is the point. Yes. Expresses it much more clearly than I did. I apologise, but but nevertheless, I say that there is that inconsistency. Two other points, if I can take them, in relation to what the Secretary of State indicates that its interpretation is right. And that the first is the need for clarity and certainty. Our response to that is that that doesn't actually add anything to the argument, because if there is a proper application of the relevant principles of interpretation, one should get to a clear and certain position. And in any event, there's no practical problem with having an interpretation that would allow for a condition in this case, or indeed in any other similar case, because through either enforcement proceedings or through applications that can be made under the Town and Country Planning Act system, whether or not and what is the proper interpretation of the document will be the subject of determination through those processes. So if there's an uncertainty, it may arise, and it is then determined through the usual processes. That's indeed no different from many other areas of planning law where there are uncertainties with regard to the existence of a planning permission in any particular case. For example, if there has been an abandonment in a use class case, or if there's a question as to whether or not a permission has been implemented. They are uncertain until they're determined, but once determined, they are clear. The second
that doesn't wholly answer the need for clarity and certainty, does it? I mean, if you can only get clarity and certainty through litigation, it's a pretty unsatisfactory state of affairs for members of the public, intending purchasers of the land.
That from one perspective is true, my lord, but at the same time, there is a need in many other spheres for clarity and certainty in leases, in contractual documents, none of which or rather all of which have the potential to be looked at by parties much further down the line, who are not the original parties. Of course, the law would strive for certainty and clarity, but it doesn't happen in other areas of law either. One doesn't then just simply abandon the attempt to seek a solution, or one doesn't, looked at from another perspective, simply reject any potential corrective solution as a matter of principle.
But you can't be looking for a corrective solution. You have to say that that all you need is actually imminent in this document.
My Lord, as I was saying it, I was aware that I had restricted my answer just to corrective interpretation. It isn't simply that.
I mean, that's one of the difficulties. That you accepted earlier that a third party, or indeed the authority itself, could have brought proceedings to quash this decision.
Yes.
And ex hypothesi, that's because there's something wrong with it. Presumably, a failure to take account in the decision of the need to impose the condition restricting the use. And you're a bit on the horns of a dilemma, because you're now trying to say, well, in fact, there's nothing wrong with this decision. The restriction is actually there.
Quite so, my Lord. When I acknowledged that there would be the ability to seek to quash, that is on the basis that the authority simply accepted, all right, well, we have an invalid document here. We should just go about the route of quashing it, rather than argue all the other issues. I don't mean by that statement to be taken to have accepted that the arguments of the Secretary of State are right. Mm-hmm. It's very much on that conditional basis, and that, as it were, removes me from the horns of that particular dilemma.
Yes. And of course, if it's simply a mistake that has to be corrected, if this were a contract, you would rectify it.
Yes.
But in the statutory context, the equivalent would require the payment of compensation.
That is one aspect. It's an aspect that I need to deal with in the context of Mr. Lockhart-Mummery's submissions, and I'll come on to that, if I may do, in a short while. My Lord, I was going to deal with the issue that raised by the Secretary of State that here we have an independently viable permission. I mean, of course, it's right, as I said earlier on, that on the face of it, it is an independently viable permission, but it doesn't actually do what it's supposed to do if it is read in a way other than that which the local planning authority says. So it doesn't actually answer our contentions. So can I then deal next? I should say that's the completion of my submissions on the interpretation, straight interpretation point, rather than corrective interpretation.
Are you going to show section 73 to see what is the power which is being exercised?
Yes, my lord. If my lord takes up the second volume of...
Well, it's actually set out in your case at page 84, isn't it?
Indeed, my lord.
MS 84.
It is, my lord, yes.
It's important to see what, presuming one's got to interpret this document in the context of the power which was referred to at the top of the document.
Absolutely, my lord. And my lord is of course alive to the point that Section 73 is a jurisdiction. Whilst it grants a permission, one is looking solely at the conditions that should be imposed on it.
But it says in 2, the authorities shall consider only the question of the conditions subject to which planning permission should be granted, and if they decide it should be granted to different conditions, shall grant permission accordingly, and if they decide it should be granted without, then shall refuse. So that's what they're concerned with.
Absolutely.
So anyone reading with this document would know that what it was about was deciding whether to keep the same conditions or to change them. And they would see that there was an original wording and a proposed wording.
Yes.
And the proposed wording is approved.
Yes, my lord. With respect, yes. Can I then, unless Lordships or my lady have any other questions on that part of my case, move on to the Chartbrook jurisdiction? As I said, I would deal with the principle, although now I tread somewhat carefully insofar as my lords and lady are clear, no doubt, as to the extent of the Chartbrook jurisdiction. That jurisdiction was contained within the decision itself at page 564 in the first volume of Authorities. By way of, the Eastern Pantiles plant hire decision. But when looking at the principles contained within Chartbrook, and can I say at the start that there's a suggestion by the Secretary of State that this should be looked at as in some way an out-of-date decision and simply as a part of the general standard interpretation approach. It is more than that, insofar as what one is looking for is a mistake that would lead to irrationality or ineffectiveness at law, which in effect, in my submission, is a recognition of the fact that if one has an irrational position on the basis of the language of the document, is such that no reasonable party would ever have agreed to it in negotiation. So there is a certain additional element to the principle set out in Chartbrook beyond simply standard interpretation. But what I'd ask my lords and ladies to look at paragraph 23 is what was said by my Lord Justice Carnwath, as he then was, in the KPMG case, that what one is trying to do is get as close as possible to the meaning which the parties intended. And of course that is an intention that is capable of being considered on an objective basis, or should indeed be considered on an objective basis, and thus is capable of being applied directly to the terms of a planning permission. And my lords, the point about irrationality...
I said that, I mean, that, these aren't two separate exercises, and that's what I think the House of Lords agreed with, but one's trying, it may be convenient to sort of divide them up. At the end of the day, one's trying to get to the understanding of the document.
Yes. In terms of the Chartbrook principle, as I say, there seems to be a rationale behind it when one's looking at the need for there to be some irrationality in the outcome of the language, that it seems to be additional to the general principles of interpretation. But as to the touchstone being to try to arrive at a meaning that is as close as possible to what the parties intended, that is something that is reflected both in standard interpretation and in corrective interpretation. And we've set it out in our written submissions. The need for arbitrariness or irrationality in the outcome is to be found specifically in the Pink Floyd case, and for the court's note, that can be found at page 916 in the bundle. I don't ask my lords to turn to it at this stage, and paragraph 20 of that decision. But the principle was extended in part in the Scottish, perhaps less extended and more further defined in the Scottish Widows Fund and BGC International case. My lords will find that at page 990 in the bundle. And I turn straight to the decision of Lady Justice Arden, as she then was. And paragraph 23. Bottom of page 990, where Her Ladyship says that in ICS and Chartbrook, the effect of the literal construction of the mistaken language of the parties was to produce interpretations that made the instruments ineffective in law or rational and arbitrary. That is evidence in itself that something must have gone wrong with the language. Equally, however, in my judgment, it must, consistently with principle, be possible to reach this conclusion in other ways. In this case, it could be said that something must have gone wrong with the language if the provision in question is inconsistent with some other provision which it is clear must have precedence. That has chimes in our case, I would submit, insofar as in this case it's obvious what, by way of Section 73, was the intent behind the document. Something obviously will have gone wrong with the language, and there will be an inconsistency with that jurisdiction. The next point that I want to deal with is the extent to which Chartbrook is capable of being directly applied in the case of a planning permission. And of course, the Court of Appeal accepted that Chartbrook was capable of applying. There were, though, certain aspects that were regarded by the court in this particular case as objectionable, which I'll turn to shortly. Nevertheless, it has been applied. It was applied at first instance in the Newark case, as the court has seen, we have referred to. Again, I don't ask the court to turn that up, but for the reference, at page 849, it can be seen that it was regarded as in no way difficult to engage Chartbrook in the case of a planning permission. The other reason why there can be the application of Chartbrook in the context of a permission is in part because in the Trump decision, of course, the court identified that one should be seeking to not take a fundamentally different approach to interpretation generally. But also, there are, in a sense, parties that can be considered in the context of a planning permission. Because a planning permission is considered by a local planning authority to be appropriate, to be granted, on the basis of an application from the applicant. Those two bodies represent, at least from one perspective, the parties to that planning permission. Of course, there will be third parties, but third parties on the application itself will be parties who will have made representations through the application process. And so their role will be arbitered, as it were, through the local planning authority's consideration of those representations. So one does come to a document ultimately that is reflective of the parties' intentions. And if perhaps that submission is too widely put in the context of planning permissions generally, it certainly isn't in the context of this case, where there was a very clear position taken by this applicant and a response by the local planning authority. On the basis of those submissions and those that we put in writing, we say the Chartbrook jurisdiction is capable of applying here. And they're satisfied, we say. They're satisfied because there has been a clear mistake in the language. If our first submissions on interpretation, standard interpretation, do not find favour. Because what has happened, and all that has happened, is that the condition in question has been put in the wrong part of the document. Yeah. That's it. That is an expression of language, or to put it another way, to get to a solution is to rearrange the words that appear on the face of the instrument. And that was what Lord Justice Lewison said in the court below was the requirement for considering whether to engage the Chartbrook jurisdiction. It's paragraph 53 of that judgment. So all one has to do is rearrange the words and put those words below the condition section, or, putting it another way, one simply needs to have some correction to the words in the description of the summary of reasons for granting permission that makes reference to the condition above, both of which are perfectly possible and capable of being done.
Which words would you move?
Well, a very simple one word is actually what I would ask for in this context. And if my lord if the court looks, please, at page 442 in the core volume.
Yes.
Where in the last few lines under the summary of the reasons for granting, it says planning permission should be granted subject to the conditions listed below. That can simply say above and below. So 2 words, in fact.
I wonder if you might put it this way, that whereas Section 73 itself envisages in terms an application for planning permission for the development of land, which can be granted subject to conditions which represent a variation of earlier conditions. The way that Lambeth have framed the decision, they have treated it as an application for the variation of a planning condition. They've granted that application. They've made it subject to certain additional conditions, which we see out, as you set out, and that is it might be criticised as being, to say the least, a clumsy way of expressing what Section 73 envisages, but that's how it has to be understood.
Yes. Yes, that is an alternative way to consider this document.
Oh, I mean, that's what it says, isn't it? It approves the following application for the variation of condition as set out below.
Yes.
And then the application, we're told, is for variation of condition 1 to allow for the sale of a wider range of goods, etc. And then we're told the proposed wording, and at the top of the next page. And then we're told under the summary of reason that having weighed the merits of a proposal, it's considered that planning permission should be granted. So they've granted, the way they've expressed themselves is in terms of granting planning permission for the variation of a condition. And one has to translate, one has to translate that in terms of Section 73 as meaning planning permission for the development previously approved. subject to this variation of a condition and the additional conditions listed.
Yes. That's certainly another way that the document can be read. Can I then, deal with the 3 points of the Court of Appeal's objections to the Chartbrook jurisdiction? The first point that's made by the Court of Appeal is that one can't supply a whole clause by way of the corrective jurisdiction, and that part of the judgment can be seen within the core volume at paragraph 56, page 194. Where, relying on the Cherry Tree Investments and Landmain case, Lord Justice Lewison said that in the contractual context, a corrective interpretation cannot be used to supply a whole clause which the parties have mistakenly forgotten to include. The Cherry Tree decision is within the first volume of authorities at tab 5, and the relevant part of the judgment relied upon by Lord Justice Lewison is at page 621, paragraph 131 and 132. It said at 132, even the staunchest advocates of the court's ability to consider extrinsic evidence stop short at saying that by the process of interpretation the court can insert whole clauses that the parties have mistakenly failed to include. What we say in terms of Cherry Tree should be the approach is that which was adopted by Lady Arden in her position in the Court of Appeal. She found that one could have a correction in this case. Her judgment is a 604 and following. What was being considered in this case was the ability to amend the statutory power of sale by way of a charge. The clause that enabled the amendment to the statutory power of sale was included in the facility agreement rather than the charge itself. And so what the court had to do was, the corrective interpretation was to read the facility agreement clause as being within the charge. So a wholesale reading in of a particular clause into the document that could, as a matter of law, cause the statutory power of sale to be amended. And Lady Arden concluded that that was possible. Didn't go into what is relied upon by Lord Justice Lewison, namely the inability to read in a whole clause. But the effect of her judgment is that she was willing to take that step.
Was she in the minority on it?
Yes.
But on your approach, you're not having to read in a new clause. You're effectively having to read the document as having put a clause in the wrong place.
Yes. That's quite right. Quite right. But in any event, I do say that what the Court of Appeal has there expressed as being an in principle reason for rejecting the case that was put forward before that court is wrong. Because it narrows the Chartbrook jurisdiction wrongly, I say. And if my lords look at the way in which Lord Justice Lewison justified that conclusion, it's by reference to two articles. The first of which, of course, must be afforded considerable, great respect indeed, the decision of Lord Nichols. But perhaps the most important one for my purposes is what is said by Professor Burrows, paragraph 133. Because the justification for...
Wait, 133 of what?
133, forgive me, my lord. 133 of the Cherry Tree decision.
Oh, I see, yes, sorry. Okay. Yeah.
The justification is that the omission of the clause would not be obvious from the document itself if one was trying to insert a whole clause. But that isn't a point of principle, because, of course, there can be circumstances where it is obvious from the document itself that a particular clause has been omitted. And so is, in my submission, a false justification. And indeed, it goes contrary to the original jurisdiction as it was identified by the court in Chartbrook, which itself derived from the ICS case, where it was indicated that no amount of red ink would be prevented to arrive at what needed to be done in order to get to the presumed intention or obvious intention of the parties. The second point made by the Court of Appeal is to be found in the core volume at paragraph 56, page 194, which I say wrongly sets out the corrective jurisdiction, because it's said by Lord Justice Lewison that in the contractual context, a corrective interpretation cannot be used to supply a whole clause which the parties have mistakenly forgotten to include. The quotation from Lord Huffman demonstrates a corrective interpretation can only be invoked where something has gone wrong with the language of the contract, as opposed to something having gone wrong with the implementation of the bargain or the mistaken failure to exercise a power. And what was being concluded upon by the Court of Appeal was that we had failed to invoke a power. I say that doesn't set out properly the corrective jurisdiction, because in a sense, where there is a mistake in the language, there will always be the non-implementation of the bargain or the non-exercise of a particular power, because the wording is wrong. That is not the correct, that is not a reason for, or not the limits of the jurisdiction. What one is looking to understand is whether, as I've said earlier on, when the mistake in the language is identified, is there an irrational outcome or an arbitrary outcome, or is it an outcome that is ineffective in law? And when one approaches the jurisdiction on that basis, it gets away from the need to consider the question of the ineffective exercise of a power.
Lord Justice Lewison is, I assume, having in mind when looking at this as a whole missing clause situation, that if the local authority had adhered to its previous practice, it would have spelt out the words you say are perfectly satisfactory, both in the grant of permission and again in the condition, as, for example, on page 434 in the 2010 decision, where they are repeated as an extra clause by way of condition. But actually the repetition isn't that different from the grant.
Yes, that's the way in which Lord Justice Lewison certainly was looking.
So he's, as it were, taking previous practice as a guide to what went wrong.
As opposed to looking at the document as a whole and reaching a conclusion as to whether or not in truth should be a corrective interpretation. But I do say that corrective interpretation can extend to imposing a whole condition under the condition section if that is necessary to arrive at the obvious intention.
Yeah. If for some reason the format of the decision notice has changed between 2010 and 2014, and the 2010 one follows the scheme of Section 73 itself. It's the permission for development. And the mistake that's been made in 2014 in this new form of notice has been treating it as a determination of an application to vary a condition.
There's also, it's a point that perhaps can be forgiven for having set out the wrong position, but there, in fact, wasn't a full repetition of the condition in the 2010 consent. There was the relevant restriction was just in the condition section and not in the first part of the description itself, which was simply referring to the variation of condition 6. So there was a difference between those two consents in that way.
Well, the one on page 433 was not specifically under section 73, was it?
Not specifically, well, no, but that's certainly how it was regarded.
Well, when you look at the proposed development on page 433, it's variation of condition 6.
It is.
Oh, yes. I mean, it was obviously intended.
Obviously
I'm just saying as a matter of form.
Yeah.
I'd say.
The second one has specifically I mean, we don't know why they changed the format, but the second one does specifically refer to section 73, and
Yes, it does.
therefore clearly you have to interpret it with that in mind.
Absolutely. Well, the third point that I wanted to deal with in terms of the Court of Appeal's objection to a case for a corrective interpretation is the point that was made about the lack of a reason being included with the omitted condition. And we'll see the way in which it was put by Lord Justice Lewison within the judgment at paragraph 59. I don't propose to read the entire part of the judgment. It's 195 in the bundle, forgive me, of the core volume. I don't propose to read the whole paragraph. But what was being said by the court was that there was a statutory requirement for the imposition of the reasons for the condition. Their full reasons needed to be stated clearly and precisely within the notice if a condition was to be imposed. And the significance of that is set out at the bottom of paragraph 59, where it said there would be no reason for a reasonable reader of the decision to suppose that a reason for an unexpressed condition was contained in a document which was simply part of the background, which deals with a part of the case that I was contending for. One could find a reason in the 2010 consent. But in fact, if the court goes a little higher up, paragraph 59, it says this: to impose a condition without giving reasons for it would be a breach of statutory duty. It is one of the principles of contractual interpretation that one should prefer a lawful interpretation to an unlawful one. The response that we make to that is that there wasn't a breach of the statutory duty here because the relevant condition wasn't imposed by the local authority specifically. If we are right that there is a need for a corrective interpretation that comprises a full re-imposition of the condition.
Triumph for form over substance in looking at the statutory obligation to give reasons. I mean, if the document is to be construed by whatever route, Chartbrook or otherwise, as containing the condition, then surely the statutory duty to give a reason must apply to it.
I accept
no matter by what weird and wonderful route you get to the conclusion that the condition is there.
Yes, I certainly accept that the principal part of my case is that the condition is already there, and in which case it was imposed, and in which case there was a requirement for a reason.
I mean, you haven't got to implied term yet, and we may have a similar issue there. But for all purposes concerning with construction, we're asking what the document means.
I accept that. But my principal submission is that if there is non-compliance with that particular requirement, namely the reason for it, that should only be evidence going to what the document means. It is not a basis for rejecting outright the proper interpretation of the document.
I mean, well, if you're simply keeping the condition that was there before, why do you need special reasons for it?
But that is the other. That was the other response that I was going to give. That in fact, in this case, the reasons are apparent.
Well, the reasons will have been given when the condition being varied was originally imposed.
Yes.
And you're now relaxing it to some extent. I don't see why you have to give reasons for reimposing what's left.
Quite well. In any event, there was a basis upon which the 2010 consent was granted. It was quite clear on what basis that was granted. And a similar reason would be granted in this case, particularly as one can see in condition 3, there was a transport assessment requirement in any event. And the first, of course.
And you normally don't have to give reasons if you're granting somebody what he's asked for.
That's true too. There is in any event, the point that the Court of Appeal was making was, I say, an artificial one. Forgive me.
Is that right? The purpose behind the requirement to give good reasons, surely, is that anybody who reads the document then understands, subject to a planning condition, what the reason for it is. Thinking, say, of buying the land, of his prospects of getting it changed, because he can look and see why the council is restricting, in the case of a use. Well, that's all they asked for.
In this case, yes, is my principal submission. It is enough because one could see quite clearly what the nature of the condition was that was to be imposed. It would be different, for example, if what one was trying to do was understand whether or not an entirely separate condition that is said to arise from the extrinsic background should be implied into a particular document. In those circumstances, one might need to understand the reasoning in order to say, well, the document must have meant that it included that condition. But in circumstances where there is all that one has done is responded precisely to the application that has been made, one doesn't need that reason to be clear as to what the document means, which is, of course, what one is getting back to.
How does all of this fit with Section 73? Because the idea that this is a variation of condition suggests that the fundamental part of the condition remains and it's varied. But that is not what Section 73 is about, is it? It's the determination of applications to develop land without compliance with conditions previously attached. And it operates to wipe the slate clean and start again. So all that would be fine if it really was a variation of condition and the background remained unchanged. But it doesn't.
Well, in this case, of course, the consent that's granted under the 2014 permission was for, on the face of it, a permission that was restricted in terms of a sale of goods, all goods apart from food retailing.
Doesn't it become a new condition?
It does become a new condition it becomes a new permission allowing the development.
If it's a condition at all, in its varied form, it's a new condition.
It's a new condition.
I mean, I think you accepted that the wording of the document on page 441 doesn't reflect the wording of the statute. I mean, it talks about a variation of a condition, whereas in fact, technically speaking, that's not what it is, but it's pretty clear one could argue that what they were trying to do.
Yes, it is not on any basis an elegantly worded permission. Of course not. But in terms of what it was seeking to do, it was seeking to impose the new condition to allow the continued use of the premises for certain specific uses, and only those uses.
Am I right? I think there's authority that absence of reasons for a condition doesn't invalidate the condition. Is that right? Is that I'm sure we'll know.
Yes, well, of course, the Dover case that was before this court.
We went into that, but I mean, back in the midst of time when I used to do all this sort of stuff, I seem to remember that it was established fairly early on that failure to give a reason for a condition didn't invalidate the condition in a subsequent enforcement.
I think it's fair to say that the position has now moved on, but I will check, if I may, over the lunch and adjournment.
I take it from what you've said thus far on this point, if you've got to the end of your submissions on it, that you're not taking issue with Lord Justice Lewison's rejection of your previous reliance on the 2000. In the middle of paragraph 59, when he asked you, where do you get the reasons, you took it back to the 2013.
I did. No, but the way in which we put it in our written case is that one actually can look at the 2010 consent.
You're already going back now to 2010.
To the 2010 consent. But I do hold on to that, but it isn't my principal case, I have to say.
It strikes me that the starting point is that the respondents are seeking to rely on this decision notice as a valid document, granting an application under Section 73. However ineptly structured it is. And so we have to interpret it, insofar as we can, on that footing. Because they can't effectively approbate and reprobate. I mean, if it's a valid decision under Section 73, well, we have to interpret it as such.
Yes.
If one construction would appear to validate it, namely that this isn't a condition, and another would appear to invalidate it,
It would, but the first construction that we propose is, and nevertheless remains, a valid consent.
An interesting point. This. I mean, one has often the problem of documents which could have been challenged at the time, but weren't. And so surely after that one has to go on the basis that they're valid and do the best one can with them. One can't sort of reconstruct the possibility of there being challenges invalid.
Yeah. I think Lord Justice
Lewison is making a slightly different point, which is that sort of somehow retrospectively you should take into account of the potential invalidity.
The issue is not whether this condition is found to be there as a matter of construction. We should now consider treating it as invalid. It's always been accepted to be valid. The issue is whether conducting the construction exercise in that way is undermined by the consequence that if you do, it then appears to be the supposed condition appears to be unsupported by a reason. Leaving aside your submission about incorporating the reasoning from 2010.
Yes, but I also proinate the fact that there is essentially a reason or a purpose behind the condition, which is to reflect the application. But the lack of a reason, even if there was a lack of a reason, doesn't invalidate the document.
No, that I don't think is the point at all.
Absolutely, and the Court of Appeal, I don't think their position was that that it did so, but it was a reason that was taken into account for the purposes of reaching the conclusion as to how the document should be interpreted. In any event, there is another aspect, of course, which is that, again, bearing in mind that one has to construe this as a valid document, the Bernard Wheatcroft case, if it's to be taken into account, would indicate that it would be contrary to the principle that you can't have a substantial alteration of the permission if you could regard this as a consent without that condition, which my submission is more powerful than the existence of those explicit reasons. There is another aspect that it would be fair to note as a potential interpretation in any event of the document. And that is, if one is looking for reasons for that particular condition, if that proposed wording is regarded as a condition, one can see the summary of reasons for granting permission, which does of itself set out at least some reasoning for that decision. Now, they may not be good reasons, and potentially they could be regarded as not complete because they are described as a summary, but are capable, nevertheless, of being regarded as the reasons for it. Lady, that was what I was going to say in respect of the Chartbrook jurisdiction. I was then going to go on to deal with implication, if I may. And the conclusion of the court in Trump was clear, we say, albeit that it was based upon a consent issued under the Electricity Act 1989, insofar as it said that there was the ability to imply words into a condition. And that same approach should be capable of allowing the implication of a whole condition if that is appropriate. I've already said that actually one doesn't need to go so far in this case as to imply a whole condition when the implication of simple words in the way that I expressed them earlier on into the summary of the reasons for granting the consent would be sufficient to achieve the same purpose. But if one is looking at the point of principle and the ability to impose a condition wholesale into a consent, we say that that is possible. And a number of reasons for that. The first, of course, is that the High Court and the Court of Appeal didn't say otherwise. Trump, secondly, albeit on an obiter basis, when one looks at the basis for that decision, one can see that it would be open to a court to imply a whole condition. The third reason is that in other cases, after Trump, there has been a clear position taken by the courts that a whole condition can be implied. The particular case I was wanting to refer the court to is the France and Kensington and Chelsea case, which can be found in the second bundle of authority, bundle 3, forgive me, bundle 3. At page 1548. Where the Court of Appeal rejected...
What's the MS number?
1548.
1540?
48.
1548. Yeah.
Paragraph for you.
It's 118.
118.
Yes. This was a case that was looking at, in substance, as to whether conditions, 6 conditions from one consent, list of building consent, were capable of being read into another consent, another list of building consent. So 6 whole conditions were being assessed and as to whether or not they could be included in the other condition, the other permission, consent. The court rejected that position on the basis that the particular wording was such that one didn't have consistency between the two consents. But what the court didn't do was say that as a matter of jurisdiction, it wasn't possible to go through the process of invocation on that basis.
Well, surely all they did was to cite what we had said in Trump.
Quite, they follow Trump.
I mean, why does that take us any further?
Only that there has been the application of the principle. Perhaps if the principle is already set out by...
Well, we said
this
what we
court.
said, rightly or wrongly.
Indeed.
The Court of Appeal didn't need to apply it, so there we are.
Are you coming back to your implication of the words above and as all you need to do?
Yes.
Oh, good.
It goes a little further. It does go a little further insofar as it allows for the ability to imply a whole condition if that is what's necessary. But
Well, the reason I ask is that might it not be said that sticking an above and before below falls foul of the principle that your implied provision mustn't contradict or be inconsistent with an express provision? If the express provision is below, putting it above and is not just an implied term, it's a complete alteration of what had previously been said.
Well, what it is, I accept that that's one argument that could be made, but I say it's not a compelling one insofar as what it isn't saying is that it's the full conditions. The France case was a case where it said that the full conditions are set out below, and that was identified as inconsistent. But if what one is saying is that it's above and below, it doesn't mean that there is an inconsistency in those two approaches, unless one reads the below as being only those below. And of course, the way in which the Secretary of State puts his case, that there is a statement within the document to the effect that when it says that it is granting the permission subject to those conditions, it is granting them only subject to those conditions. But there's no basis for that conclusion by submission.
Well, aren't the conditions required to be set out in full and expressly and given reasons? I mean, the whole discipline under which these grants take place is that you find all the conditions in the document.
Indeed. But in order to get to the obvious meaning of the document, or the obvious intention behind the document, one can get to that conclusion by way of a reading that allows the earlier part of the document to be regarded as including that condition. I was going to deal with other cases that identify the ability to imply a whole condition into a planning permission. And I was going to rely on what we said in our written submissions to the effect that in non-planning cases, it's clear that where there are public documents, the courts are still able and willing to imply a wholesale provision. And one can see that in the Attorney General and Belize case, which the court referred to in Trump. Perhaps if the court can turn in that regard to page 511 of the bundle, which is in bundle 1. And this was a case that concerned whether or not there was a provision that should be implied into articles of association to the effect that a director who is appointed by way of special shareholders should be capable of being de-appointed if the special shareholder no longer held the relevant interests. And if the court turns on to page 517, the relevant principles are set out in paragraph 22 and following. But the approach that the court took was that one could make that sort of implication in circumstances where the document itself spelled out what the meaning of the document was and what a reasonable person would understand the document to mean. And the Articles of Association have a degree of similarity to the position of a planning permission so far as it comprises a public document. And there will be other parties concerned with the nature of the meaning of that document. And if my lords turn to page 520 in the bundle, the board's decision referred to the case of Bratton and Seymour, paragraph 35. The court made the observations that derived from that judgment that there are a limited number of documents that may be considered in the context of Articles of Association. And importantly, what the court then said at 37 is what was being considered by way of the matters in this case. The board does not consider that this principle has any application in the present case. The implication as to the composition of the board is not based upon extrinsic evidence, of which only a limited number of people would have known, but upon the scheme of the articles themselves, and to a very limited extent such background as was apparent from the Memorandum of Association and everyone in Belize would have known, namely that telecommunications had been a state monopoly and that the company was part of a scheme of privatisation. So what the court was taking into account essentially was what was within the four corners of the document as being the principal matter that should be considered. And so there are and is a basis for the conclusion reached by this court in Trump by reference to the Attorney General case, allowing implication into a planning permission. And indeed, that's no different. That position is no different, as I've said already, from the long lease example, when the parties themselves may have long since had no involvement in the case. So can I then deal, please, on the basis of that series of submissions, and I ultimately say that there is the ability to imply a whole condition if that's appropriate, with the third respondent's arguments. Because the third respondent takes a point both in respect of implication and indeed Chartbrook, to the effect that one should not adopt those two approaches as a matter of principle in this case, and does so by reference to two particular arguments. Firstly, that there is a comprehensive code in the planning sphere, and the introduction of the power to imply or to correct by interpretation should not be regarded as a supplementary part of it. And the second is that it's inappropriate to use contract or property principles in the context of a planning permission. Can I deal firstly with the arguments relating to there being a comprehensive code? The first point I make is the inconsistency in the third respondent's case in relation to this matter, because the third respondent accepts, at least on the face of it, that one can have the implication of an incomplete condition, or one can have implication into an incomplete condition. So words can be implied into an existing condition, in short, in the attempt, it's obvious, to try to fit within the terms of Trump. But there isn't any point of principle, we say, between an interpretation of part or wording into a condition and the implication of a whole condition. What justifies the former position should also justify the latter. The second point that we make about the comprehensive code is that the decision in Trump actually followed a long pedigree of other decisions that were referred to by my Lord Carnworth in the Trump decision, Crisp from the Fens, for example, and Fawcett case. But also, one can see it in the Francis and Useley decision that I said I'd return to earlier on in my submissions. And if my lords turn to that decision, which is within the first bundle of authorities and 672, the facts are somewhat involved, but concern whether or not there was an enforcement notice that was validly placed upon land preventing the use for the siting of caravans for residential uses. But one of the questions for the court was whether and to what extent there had been a permission granted for that caravan site by the minister who was the decision maker at that stage, and whether it was restricted to an express condition for 6 months' use only. And that was not dealt with in terms on the basis of implication by within the judgment of Lord Justice Jenkins, who gave the lead decision, but was dealt with by Lord Justice Parker at page 687 in volume 1. If my lords read through the first 7 lines, I may ask they do so, at 687. Lords will see there was at that stage a clear position taken by the court that although there was no express condition saying that the caravans are to be removed at the end of 6 months, nevertheless such a condition needed to be implied. And there was a suggestion made by the third respondents that the crisp from the Fens case that my Lord Carnworth referred to in the Trump decision was not actually an implication case, but was in fact simply a standard interpretation case. But if my Lords turn to page 646 in the first volume.
Sorry, page?
646.
Thank you.
Where Lord Justice Denning's decision is set out, and I don't repeat the facts unless my Lord's a lady would like me to do so. But if my Lords turn over, as I say, to 647 and the last paragraph, what ultimately needed to be considered is whether the relevant condition which is to be found at page 636 in the bundle. It stated that the use of the building should be confined to the manufacture of potato crisps or any use within Class 3 of the Town and Country Planning Use Classes Order should include, in fact, the word any other use within Class 3. And Lord Justice Denning said this: it would be unfortunate if the amenities of the small country town like Oakham came to be taken away owing to the slip in omitting the word other in the wording of a condition when the parties knew perfectly well that the amenities were intended to be preserved. And it's then said it's a case where a strict adherence to the letter would involve an error in substance. And so this was in truth an implication case because a whole word had been omitted from it.
Yes, and you would say the inhabitants of Lambeth are entitled to similar protection.
I do. I do. I haven't made reference greatly to the point, but there is, of course, here a particular significance in a conclusion of this court that there is an open retail use, insofar as the traffic implications will be significantly different from a non-retail use, which of course was the subject matter of consideration by the planning authority and the reason for the imposition of the condition. And so there is a long history behind the implication process, and that shouldn't, we say, now be revisited, and nor need it be revisited by this court. The third point that I make in respect of the Comprehensive Code argument is the fact that the decision in Pioneer, which is referred to by the third respondents, and which the court will no doubt have seen, it says that if there is a comprehensive code, as there is with planning, it shouldn't be supplemented in circumstances where the statute covers the situation. That principle does not apply here, because there is a need in the circumstances to use the implication provisions. It is true that there is a revocation and modification power, but even the third respondent in its express case had in its case set out in paragraph 30 actually says that you couldn't impose a whole condition by way of modification or revocation. I have to say, I think that must be an error on the part of the third respondent in making that sort of observation, but nevertheless it does. I take it that it's made a mistake on that basis. If I'm right about that, nevertheless the power to revoke and modify is limited, because if my lords turn to that power which is at...
Well, you'd have to pay compensation.
You have to pay compensation.
It would have to be confirmed by the minister, and you'd have to pay compensation.
Indeed so. But it also has limits to its applicability. It can't be used in circumstances where the operational development has been completed, or where the material change of use has occurred, which is the subject matter of the permission that you're seeking to modify. So it isn't a wholesale provision that would be properly regarded as excluding the ability to imply. On that basis, I don't propose, given I'm aware that I have a limited time to complete my submissions, I won't refer the court to. I will, though, turn to the second aspect of the third respondent's case, namely the irrelevance of contract or property law principles, because there is a different juridical basis for each of those approaches, and they shouldn't be used to supplement the public law system on that basis. Well, the proper approach of this court, I say, is not to focus just on the juridical basis for the decision for the approach in question, but as to whether or not those principles can be applied sensibly and appropriately. And they patently can. Indeed, they are applied in a different context, insofar as even the third respondent doesn't suggest that the common law principles of interpretation should not apply to a planning permission. And if one can adopt that approach towards interpretation, then implication should be regarded as being no different. And of course, if one is looking at the unified approach that was adopted by Lord Hoffman in Belize, for example, there is no difference in principle between the application of interpretation principles and implication. In addition, the tests that one needs to, or the test that one essentially needs to apply when considering implication, and that is what is the presumed intention of the parties, and what is, or rather what is the objective purpose of the parties, is something that is patently capable of being applied to a planning permission, for the reasons that we've set out previously. On that basis, then I turn to the question of to whether or not it's possible to imply a condition into a permission by reference to this particular consent. Before, though, I do that, perhaps if I can just touch upon one part of the decision of the Court of Appeal, which is to be found at paragraph 73 in the paragraph 73 of the judgment, and in the core volume is at page 198. And this returns to the significance of the absence of a condition. Perhaps my submissions have already been made on this issue for the court's purposes in respect of interpretation, so I don't need to go into those in any greater detail, other than to say this, that the absence of a reason to be attached, the absence of a reason for a particular condition that is to be implied, is something that should be regarded simply as evidence for or evidence in support of or contrary to implication. It shouldn't be regarded as an in-principle basis for rejecting implication entirely. Because what, in fact, the Court of Appeal appears to be seeking to do is say that unless the reason is apparent, then one can't have implication. See the last 3 lines of paragraph 73.
Well, that's just a way of saying that if what you're trying to imply is a condition, then you've got to imply the reason as well, so that the presence or absence of a reason is subject to the same sort of necessity and obviousness tests as apply to any other aspect of implication.
Yes, but at the same time, as I say, one can imply a condition or, for example, part of a condition because of the circumstances that exist, both from the document and any extrinsic evidence. And the fact that you don't, in certain circumstances, have a reason isn't and shouldn't be an in-principle ground for rejecting it entirely. It may be a factor that needs to, and indeed is a factor, of course, to take into account when deciding whether or not the implication should take place. But I don't return to what I've already said, namely that if one needs to find reasons, one can find those reasons within the document itself. So can I then turn to the subject consent and the 2 bases upon which we say there should be an implication in this case. The first is that it's necessary to give business efficacy to the document. The second is that it's so obvious as to go without saying. Looking at the business efficacy question first, can I ask, please, the court to go back to the decision in Belize and 517 of volume 1, please. Where the board set out a number of observations on the principle that, although on the test that needed to be applied. Paragraph 23, it said as follows: the danger lies, however, in
this has all been overtaken by Marks and Spencer, hasn't it? I mean, do we actually have to go through all this again?
Well, only insofar as it does make one point that I say is particularly pertinent here. in terms of the second sentence of paragraph 23, the simple point is made. It's frequently the case that a contract may work perfectly well in the sense that both parties can perform their express obligations, but the consequences would contradict what a reasonable person would understand the contract to mean. That's all I refer to. But the reason it's important for my purposes, at least, is that the Secretary of State is saying, well, this is a perfectly viable document. It works, but it doesn't work according to what the purpose of the document is. And it's that one is looking at when one's reaching a conclusion as to what is business efficacy or planning efficacy.
I mean, in your case, it's obvious what's needed to give effect to the obvious purpose of the document. I mean, the trouble about, again, all these cases, they're all different wordings of different documents. And I'm afraid we've complicated the principles in a number of cases, and it'd be nice to try and simplify them.
Well, in that case, I'd simply reiterate those submissions that I've made in writing and get to the core of the point, which is that the purpose or the presumed intention, the obvious intention, is plain from the four corners of the document. And that is sufficient for the purposes of achieving implication in this case, whether on the basis of necessity for business purposes or that it's so obvious as to go without saying. My last point, if I may make it, concerns an argument that's made by the Secretary of State in reliance on the Marks and Spencer decision, and a particular part of the judgment of Lord Neuberger, which can be found in the bundle at 774. This is a point that's derived from Secretary of State skeleton in paragraph 40 for the court's note. But at 774, the point is made 5 lines up from the bottom of paragraph 50, that it's so clear that the effect of the case law is that rent payable and paid in advance can be retained by the landlord, save in very exceptional circumstances express words would be needed before it be right to imply a term to the contrary. The way the Secretary of State uses that observation is to say, well, I'm your man, sets out a very clear line of argument, and so one shouldn't be implying contrary to that decision. But that's a false comparison in this case. What actually one should be looking at if one is seeking to identify the relevant case law that might prevent implication is whether there's any line of case law saying that one cannot impose a condition that restricts a retail use, which of course it doesn't. There's no such case being put forward by the Secretary of State. So the observation of Lord Neuberger relied upon by the Secretary of State is inappropriate, we say, and so it doesn't form a basis for rejecting our arguments. So, and lady, on that basis, we say that there should be either an interpretation in accordance with our contention or implication. And also, lady, those are my submissions, unless I can assist the court further.
Thank you, Mr. Reid. Mr. Henderson, do you follow? Mr. Klinsky.
Please, my lords and lady, before going on to my submissions in relation to interpretation, the application of Chartbrook and implication, may I deal with 3 preliminary matters, just very briefly, a couple of factual points. I appreciate Mr. Reid's covered most of the points, and also the court's indication at the outset that has taken the opportunity to look at the facts, and I'll deal with it on a canter on that basis. I do then want to identify 2 points on the statutory scheme that I say are important, and that is the provision in relation to enforcement and also Section 73. I then want to deal with the I'm your man principle, and before then coming on to dealing with the heads of argument in relation to interpretation, Chartbrook and implication. So on that basis, may I just take a couple of factual references for matters that are relevant to the background, which my learned friend didn't specifically take the court to. So may I start in the core volume at MS 422. And this is the start of this document is MS 417. This is the Secretary of State's inspector's decision allowing the appeal for the original 1985 planning permission. And the point I wanted to just specifically draw the court's attention to is starts at MS 420, paragraph 15, which is where there's some discussion of the particular road and traffic issues in the vicinity of the appeal site at 15. I just asked the court to note that for context. And then over the page at 16, we have the reasoning that leads to the imposition of the original condition 6. If I can pick it up midway through the paragraph, there's a sentence that starts indented about halfway through, because the traffic generation and car parking requirements of certain types of large retail stores are substantially greater than those of the DIY unit proposed and could, I emphasise that, be excessive at this site. It is necessary to restrict the right to change to other types of retail unit. I shall adopt for this purpose a condition on the lines that were suggested at the inquiry, and that's the condition 6 that you can see at MS 422 over the page. So the point I draw attention to as a matter of the planning history and the chronology was that the imposition of the restriction in terms of use classes was not one that was an in-principle objection, but it was right from the outset linked to traffic considerations. And when we trace through the planning history, the feature of all of the decisions is that the basis for any restriction or any express refusal to expand the range of permitted uses has related to traffic considerations. And I will say that's important for the reasons that are identified by both courts below, both Mrs. Justice Lang and also the Court of Appeal, that on the face of the 2014 freestanding planning permission, when we come to construe it, we see that the authority is exercising its jurisdiction to impose the conditions that it does on traffic grounds. So that's the point of fact that I wanted to draw out there. You've been then taken in the chronology already to the fact that in 2010 at MS 433, you have a variation of that condition, and you have the legally effective imposition of a restriction under condition 1. And that's obviously been the subject of some discussion already, but that's the next stage of the chronology. And again, at that stage, the reasons are related to highway concerns. The next stage of the chronology, again, which you've been taken to, was a 2013 refusal to broaden the permitted scope. That's at MS 437. And again, factually, the reason is highways. And then when we come to the consent that we are concerned with, just to go to it for present purposes only, just to show the role of traffic on it. I'll obviously come back to it in the course of the submissions in terms of the points that have been made by the court and by Mr. Reid in his submissions. But I do ask the court to notice, so I'm at MS 441 and 442, that when one looks at the summary of the reasons for granting planning permission, it does refer to some development plan policies. I'll show the court that that's a relevant aspect of the decision-making under Section 73, but I ask the court to note that those policies are traffic policies, and the point I'll be making when we get to Section 73 is that the essence of what the council has to consider here is what conditions to impose. It's considering what conditions to impose, and 2 of the 3 conditions that are imposed, condition 2 and condition 3, both have as their reason and as their focus concerns in relation to traffic and the highway network. Those are all matters that feature obviously quite prominently in the reasoning of the courts below. I will be adopting those points in my submissions, but I thought the court ought to just see the context of those in the factual material. May I just take one further reference on the facts, which is the inspector's decision, which the court will find at MS 449. I appreciate that the issues are legal issues and one doesn't need to detain oneself on the reasoning, but it is in the light of the way the arguments are now put on both sides, and also in the light of the Secretary of State's emphasis on certainty and workability, which is at the heart of the submissions. I would ask the court just to notice two paragraphs in this decision-making. First one is at MS 451, paragraph 16, where the inspector says, having set out "I'm your man," she says, "In this context, the only clear and certain way for the council to have achieved the desired result of restricting the sale of goods was to have imposed their intended sale of goods condition on the 2014 permission in full. It did not." So the inspector is applying, I will be submitting, a very well-known principle of restriction must be by condition. It's clear, it's workable. She's asking that question, and that's an easy question to articulate and to answer on the facts of the case. And similarly, that is what resonates in her analysis at paragraph 36, as is consistent with "I'm your man," that's on MS 455, as is consistent with "I'm your man" and unaffected by any subsequent legal authority. I conclude that as a condition restricting the sale of goods was not imposed on the 2014 permission, the legal effect is that the premises are free from any sales of goods restriction. Had the council considered it necessary to restrict the sale of goods, it should have done so by condition on the 2014 permission in the same way as it did in 2010. Now, I appreciate those aren't determinative of the legal answer, but what they do signal is that the shape of the case that is being advanced on this side is one that is rooted in some well-established principles and is easy to apply and workable, and the inspector is asking and answering questions that are clear in terms of looking for restrictions to cut down the rights to move, to change use within the use class, which I'll show the court is a feature of the statutory scheme, must be imposed by way of a condition. Is looking for such a restriction and is not finding it on the face of our permission, because it's well understood that you don't look to cut down use class rights through a description of development. You have to look for that to take place through the conditions. So those are the short points on the facts that I wanted to just draw out. My second preliminary topic is a couple of points on the statutory scheme. The court will have seen that we cover, the appellant's case sets out helpfully many of the provisions in some detail. We, in our written argument, paragraph 5, we encapsulate what we say are overall the critical provisions of the statutory scheme. For my part, I just wanted to draw attention to two headings in my oral submissions. The first one is just to invite the court's attention to the distinction between types of enforcement, because this is obviously an issue that comes before the court through an application for a certificate of lawfulness, where what was being said was that there is the ability to have a retail unit, a proposed retail unit at this site because it hasn't been restricted. And in order to understand why that comes forward in the way that it does, it's necessary to look at section 171A of the 1990 Act, which the court will find at MS 1147. This is obviously set out carefully at the outset of the Court of Appeal's judgment and framed the analysis of the Court of Appeal. So I'm aware the court will have some familiarity with this, but it is, I do submit, important to determine the issues in this case, to keep in mind the distinction in this part of the 1990 Act. So for the purpose of this Act, the 1990 Act, carrying out of development without the required planning permission or failing to comply with any condition or limitation subject to which planning permission has been granted constitutes a breach of planning control. Now, in this case, the certificate is granted because the use to move within Class A1 is not in itself development because of Article 3 of the Use Classes Order, which is set out helpfully in my learned friend's case, paragraph 21. So we're not, on any view, concerned with 1A. So what we are concerned with is whether or not there is a cutting down of that right through the imposition of a condition. That's the whole shape of the Act, and that forms the reason why it's necessary to look for a condition. Now, the Court of Appeal framed the issues in the case in that way, leading up to paragraph 37 of Lord Justice Lewison's judgment, where the court formulated the question, Lambeth can only prevent the change of use and hence the grant of the certificate of lawfulness if it can successfully argue that the change of use would be a breach of condition and thus falling within section 171A 1B. And that feature of the statutory scheme is why there is such a focus on whether there is a restriction of the use classes order by way of condition, and why the status of that restriction and the effectiveness of that restriction is such a critical issue in the case. The second point is a point that's been touched on in argument already and with some observations from the court, which is the nature of Section 73 and what the function of a local planning authority is in the determination of a Section 73 application. And then also this will inform how that fits in with the decision notice and with how they should be read. So I would ask the court to look at Section 73. If we go to MS 1118, which is within Volume 2, tab 33. The nature of the decision that's taken on a Section 73 application is to grant or refuse planning permission for the development of land without complying with conditions subject to which a previous planning permission was granted. So whilst it is a colloquialism to say it's a variation of a condition, it's not actually an accurate reflection of the function that the statute affords on a local planning authority. And I align myself with the observation, I think, of respectfully of Lady Black along those lines in the course of argument, that's what the function of Section 73 does. Now, it's also important to focus in on what the powers of the local authority is in determining such an application. That's subsection 2. So they're only considering the question of conditions, and then they have various options. So can I just look at B first? So if they decide that planning permission should be granted subject to the same conditions as those to which the previous permission was granted, they actually refuse the application. So in other words, if there's no change to the previous status, the answer under Section 73 is to refuse the application. If, however, Section A, and this is the important part, if they decide that planning permission should be granted subject to conditions differing from those subject to which the planning permission was granted, or should be granted unconditionally, they shall grant planning permission accordingly. So the whole purpose of it is to focus on the imposition of, assuming it's not an unconditional consent, of different planning conditions, forgive me. and the effect of it, which the courts have held, and it's a settled position that I don't understand to be challenged in these proceedings, is that the words "they shall grant planning permission accordingly" is what gives rise to the settled understanding that what results is a fresh planning permission, and that's the PowerGen case in the Court of Appeal, which is at tab 63, which draws on the first instance analysis of Mr. Justice Sullivan in a case of Pye, and the critical paragraphs of PowerGen are paragraphs 28 and 29 that set out in detail the analysis of Mr. Justice Sullivan from Pye and agree with it, and then come to apply it in the context of that case, saying that the upshot of this is a fresh planning permission.
I mean, you accept that although that's what they should have been doing, it's not what they actually said they were doing in the document in this case.
Well,
So we have to, although everyone accepts that it's to be treated as though it was a grant permission without a new permission, it doesn't actually say that's what it is.
but the settled legal effect.
Oh, no, I mean, there's no
the,
dispute about that. But we have to interpret the document against the background that it was an inept way of describing what everyone agrees they were trying to do.
Yes,
Well-
that's the whole problem with this. Everybody, well, in the course below, seems to be treating the first part of the document as a valid variation, so far as it goes, and then when you come to the conditions, for example, the whole thing falls apart because the development to which the permission relates is not the variation of the condition, it's said, but the erection of the building donkeys years ago. And so condition 1 falls, condition 3, by the same logic, must equally fall, the traffic generation condition, because that's also tied to the timing of the implementation of the development.
Well, I'd submit not in relation to those two conditions. I mean, may I just, taking a step back, I take the point to an extent that one has to look at, well, certainly one has to look at the words, but one has to look at the words in their statutory context. And the statutory context is that this is a fresh permission and that the inquiry is what different conditions are to be imposed upon it. In the course of argument, my Lord Carnworth observed, it's clear what they are trying to do. Now, with respect...
Do you disagree with that?
Well, no, I don't, my Lord, but I respectfully submit that's not the right question.
It's quite a good starting point.
The court...
If the document makes absolutely clear what they were trying to do and everyone knew what they were trying to do, isn't that a good starting point for interpreting?
Well, pausing there, I, as a matter of approach, I align myself with the Court of Appeal's observations in paragraph 19 that, in a general sense, it's clear what Lambeth were trying to do. That's not the relevant question. The relevant question is the legal effect of what they in fact did. And in that context, I do submit that what they were attempting to do is much less significant than the objective meaning of the words that they imposed. Now, I accept that doesn't get me past the formulation from my Lord Reid that you can, to the effect that you can read this through a prism of a variation of a condition. And I will attempt to deal with that formulation. But I do say that my Lord Carnworth's formulation of, well, we just need to think about what they're attempting to do here as a critical starting point, that I do respectfully submit, that's contrary to established authority on interpretation and Chartbrook, because the inquiry is the objective meaning of the words used, and that objectivity is, I would respectfully say, more important in a public law context than it might be in a private law context.
Is it not pretty obvious to the reasonable reader what this was intended to achieve?
Well, I will be aligning myself with the analysis of how the reasonable reader would approach this. That's set out fully in paragraph 52 of the Court of Appeal's judgment, where I say that Lord Justice Lewison very carefully drew together the relevant strands about what one can understand from the context. For present purposes.
If I may say so, one rather gets the impression that all the reference to authority have been rather a distraction from reading the document and asking yourself, what does this mean to me as a reasonable reader?
Yeah, well, the submission that I make on the Secretary of State's part is that is as found by the Court of Appeal, you have to read this document through the understanding that what is permitted in terms of the scope of what is expressly authorised through the consent is not the same thing as what is legally effectively restricted. So I accept that, that to an extent the point my Lord makes, that there's some force in the word approves on page 441,
yeah.
First sentence has to be read together with the proposed wording. So, but in my submission, the Court of Appeal correctly realised that. They said you don't read this as authorising the A1 retail use. Forgive me, the A1 food use. You can't possibly read it on that basis because it's approving a permitted use for the display of non-food goods only. So far, so good. Now, there is then obviously the tailpiece that my learned friend's case depends upon saying that the tailpiece there is effective as a restriction which basically triggers a restriction by condition for the purpose of section 171A 1A. And my submission is it doesn't, because you have to then understand it through the prism of the clear understanding that restrictions need to be contained. There's a difference, as Mr. Justice Higginbotham, as he was put it, in the Cotswold case that's referred to in the argument opposed I'm your man case, between what is authorised by a permission and what is restricted. So what is
here we're talking about a condition. It's quite clear that what they're talking about is an original condition and a proposed condition. And so one presumably would, if I'm simply looking at the document as it stands, one would say, well, what they're obviously trying to do is to substitute a different form of condition to the one that was there originally.
Well, as a Court of Appeal analysed it, the primary objective was to broaden the scope of goods that could be sold.
Imposing a different form of condition.
Well, the primary objective of this, objectively speaking, was to broaden the scope. The question, the critical issue in the case is whether, as well as broadening the scope, they effectively reimposed a restriction. And my submission is that when you read this document as a freestanding planning permission, which is what you have to do, you can't possibly construe it as imposing a restriction on the use of the use classes order, reliance upon the use classes.
Yes, I mean, what you're really saying is, well, it may, if you didn't know about the statute, you just look at this document, you might say, well, they're simply substituting one condition for another with the same legal effect. But you actually know, when you look back at Section 73, that they're actually doing something rather different, which is granting a new planning permission. And so you have to look at it in that light.
Well, I align myself. And I align myself very much with the observations of the Court of Appeal in 52, which I will come to, but they are that the reasonable reader would understand the nature of the exercise required by Section 73, would understand it would be a freestanding permission, and would understand that were there to be a restriction on the reliance upon the use classes order, it would have to be contained within a condition. Now, just for reference, both the first instance judge and the Court of Appeal, in attributing that understanding to the reasonable reader, drew upon some of the planning policy guidance that was promulgated on behalf of the Secretary of State by and it's recorded in the statement of facts and issues that is agreed. And may I just direct attention to that? So it's in paragraph 43 and 44 of Mrs. Justice Lang's judgment at MS 216. It also features in Lord Justice Lewison's analysis at paragraph 21, that's MS 185, and the guidance itself, which is cited in the Statement of Common Ground at, the Statement of Facts and Issues, forgive me, at MS 65, the relevant guidance is at MS 1289 and MS 1295. The effect of it is it's a new permission, and if you're going to impose restrictions, they need to be expressly imposed on the face of those documents.
It's interesting that it says, to assist with clarity, you should repeat the conditions. It doesn't seem to be saying that's necessary to make them valid in the second iteration of the...
Is my lady in the bit that's in...
I'm in paragraph 21 of the
Court of Appeal.
Yeah.
Yes, I'm grateful. So, I mean, that is an understatement, I would respectfully submit.
Well, it has to be on your case, doesn't it? Because it otherwise presupposes an existence for the condition without having to be restated.
Yes, which is, I would respectfully say, contrary to the settled position that, as in Power Gen and Approving Pi, that this is a freestanding planning permission that must contain the provisions on its own face, or there may be scope in certain circumstances to look at whether there's express incorporation. But the point I think my lady observed in argument, what there can't be here is express incorporation of the condition from the 2010 permission, because the very essence of this is an exercise to change that. And the way that it is changed, I respectfully say, has to be clear on the face of the decision notice for this permission. I think everybody agrees that. But my submission is in a context where, were there to be restrictions imposed on the operation of the use classes order, one would need to find those in the conditions themselves, because that is, I say, the settled position in law.
Well, they may have had in mind Mr. Justice Sullivan's decision in the Reed case, where he seems to be able to bring in some conditions which weren't actually expressed in the new document.
Well, I would respectfully submit not.
I'm just trying to help your draftsman, that's all.
Well, I'm not sure. I respectfully submit that, as for the reasons given by the Court of Appeal, Reed is a very different case. And one of the critical differences is on this case, on the face of the decision letter, we've got conditions 2 and 3, which cover precisely the same planning judgments in terms of impact of highways that are the essence of the condition that's said to be available through a process of construction or implication. My Lords and Lady, I think it might be time for the short adjournment.
I think it may be a convenient moment. Thank you very much, Mr. Klinsky. We'll resume at 2 o'clock.